The next two sections are to deal with Section 110 companies and tax structures that were put in place, ensuring that largely and typically non-resident investors didn't pay any tax on any loan books that they were purchasing or property that they were buying. And this would have generated an awful lot of media back before, probably last summer really, with the result that they had to bring in legislation pretty immediately, and they did in September of 16. But the legislation was effective from that date, but came in the form of the Finance Act 2016. There's two ends to it really. The first was to deal with securitization issues, and that was to deal with guys that would have come in and bought a loan book. If you had maybe a vulture fund may have come in with 50 million, bought a loan book for 50 million, made 50 million profit on it. The money was being advanced to the vulture fund by a non-resident investor, and it was being advanced as a profit participating note. So they would get their investment back together with a profit participation uplift, which was deductible for tax purposes on the Section 110 company, because that's the way they were structured, because that's the way Section 110 operated since the early 90s to provide the necessary tax regime for that type of activity to enable areas like the IFSC to develop. But a bit of creative thought obviously was brought to the party to ensure that those that were buying loans of banks weren't paying any tax, and there was a bit of an upset about it, with the result that they changed it to ensure that that particular payment of an interest amount or of a profit participation is no longer tax deductible and effectively becomes taxable.